Hello, this talk is on how to question young or otherwise vulnerable witnesses. Advocacy, as you all know, is the art of persuasion, and language is our essential tool. When I speak to a judge, of course I can use advanced vocabulary. I can use technical terms. I can use legal abbreviations, because I know that the judge, or at least most judges, will understand me. When I speak to a jury of lay people, I use standard vocabulary, which I believe the vast majority of people will understand. I will not use technical terms unless I can immediately add an explanation in plain language. I will not use legal abbreviations that will be meaningless to the average lay person. Why? Because if I do not adapt my approach, then I am not communicating effectively with the jury. If they do not follow what I am saying, if they do not understand me, then I cannot possibly hope to persuade them. I might just as well shut up, sit down, and abandon my case. Witnesses, and indeed defendants too, come in every variety possible of humankind. The young, the old, the intelligent, those with psychiatric problems or learning disabilities, the educated, the uneducated, the articulate, the inarticulate, the deaf, the blind, the autistic, the traumatized, the downtrodden, the strong, the weak, the brave, the fearful, those with good memories, those without, those who need an interpreter, the reliable and the unreliable, the experienced, the inexperienced, not to mention, of course, the truthful and the untruthful. With advocacy, with communication, there simply is not one size that fits all. We have to be flexible and adapt to the circumstances. It is obvious, is it not, that you would not dream of speaking to a child witness in the same way in which you would speak to an experienced police witness or to a highly qualified forensic scientist. Yet we have had problems in England with bad advocates doing just that. Even, dare I say it, some QCs and some judges. A good advocate recognises that there is always more to learn. Competent, effective advocacy requires thoughtfulness, insight, constant practice, and thorough preparation. The start point is, of course, to think about the individual witness. Ask yourself, is that person someone who is vulnerable or potentially vulnerable? Bear in mind that there is no definitive list of vulnerabilities. A person may be perfectly strong and capable in their normal home or work environment, but fall to pieces at the prospect of speaking in a public courtroom. Or that person may be a confident public speaker, but deeply traumatized when recalling a particular distressing event, especially if required to speak about something personal or private or embarrassing. A person may be capable of giving reliable evidence, but tire easily because of some health condition, and that tiredness may result in confusion or a difficulty in focusing on the questions. I want to deal specifically with two categories of vulnerable witnesses: children and victims of sexual offences. These are the most common vulnerabilities that you will probably encounter in your work as advocates, and I shall start with child witnesses. Children are not simply small versions of adults. Their brains are still developing. Their vocabulary will inevitably be limited to a greater or lesser degree. They may not be able to read yet, or not read well. They may have very little comprehension of the passage of time. If an event happened a year ago and the child is 10 years old, that delay of 1 year amounts to 1/10 of the child's entire life, which is a massive amount of time. Whereas at my age, what is 1 year? It's nothing. Ask a child how old a person is, and the answer may be really old, and yet the person may be aged less than 30. Time and frequency are not easy concepts for a young child to grasp. They may well be inhibited from saying when they do not understand or when they cannot remember something. They may be keen to please the adults. And of course, a child's chronological age does not necessarily determine its developmental or intellectual abilities. You can have a bright, articulate 6-year-old or a slow, inarticulate 15-year-old. It follows that you must adapt your advocacy to the needs of the particular child. If you do not only will you fail to obtain the best evidence from that child, but you will also alienate the jury, who will think badly of you for confusing, or far worse, for bullying a child. Remember that you are a stranger to the child, who may well have been taught not to speak to strangers. Of course, speak slowly and clearly. Look at the child. Eye contact is important. And smile, don't frown at the child. In short, be nice, not scary. Always give the child the time it wants to think before answering. Some children take longer than others to process information in their heads. And never ever bully or harass a child witness. Don't interrupt or finish the sentence for the child. Just listen politely and attentively, even if the answer is not the one you wanted. Always use the child's preferred name, and you will need to find that out in advance. With very young children in particular, it can be beneficial to use that name at the start of each question so as to maintain the connection you have with the child. Your language must of course be appropriate for the particular child, and the general principle is the simpler the language, the better it is. So ask a child, who did you see? Not who did you observe? Ask who was holding the stick, not who was wielding the weapon. Ask, was there a lot of rain? Not, was it raining cats and dogs? And ask, did Mummy like Robert? Not, describe Mummy's relationship with Robert. Be precise with your language. Pronouns in particular can be very confusing to a child. If you ask a child, when Daddy came into the room and shouted at Robert and Sam, what did he say? Who is he? That could mean, what did Daddy say? Or it could mean, what did Robert say? Or even, what did Sam say? Ask instead, when Daddy came into the room, what did Daddy say? It may sound laboured and repetitive to you, but it is much easier for a child to understand and will lead to far less confusion in the evidence. More than ever, it is essential that you use short questions, because the fewer the words, the greater the likelihood that the child will understand them. Remember that children can be very reluctant to say that they do not understand a question, even if the child has been told at the start of his evidence to say just that. Always follow a chronological order in your questions. Never jump backwards and forwards, because children can struggle with the concept of time, such as before, or after, or last month, or the week before. So if the events that the trial encompasses cover a period of time, begin at the beginning and work logically through until you reach the end. Do not jump around. Try to break your questions down into a series of discrete topics. Children find it easier to follow and to understand if you signpost what that topic is before you ask your questions on that topic. For example, you may say this to a child: Johnny, we are going to talk about Robert's house. Who was in Robert's house when you visited? When you finish that topic, again signpost that you have finished and signpost what the next topic is. For example, Johnny, we have finished talking about Robert's house. We are now going to talk about the day when you went to the beach with Robert. Or you might say, Johnny, we have finished talking about the beach. What did you tell your mother about Robert? Do not repeat questions. It will either result in you simply bullying the child, which will alienate the jury, or it will suggest to the child that the original answer was wrong and that it should now give a different answer. If it really is essential, and I do mean really essential, to clarify what the child said, word it perhaps like this: Thank you, Johnny. I want to be sure that I understand. Johnny, tell me again, what did you tell your mother about Robert? Be careful not to mix your tenses. If you are talking about something that happened in the past, use the past tense throughout. For example, if the child has explained that she was in her bedroom and Robert got into her bed, do not say, so you are in your bedroom. Robert gets into your bed. Now what is happening? Instead, use the past tense. When Robert got into your bed, what did Robert then do? Always keep in mind that the attention span of a child is very much shorter than that of an adult. Ask only what you have to ask. Watch out for tiredness and for confusion that has resulted from tiredness. Generally, young children give evidence better in the morning when they are fresh and wide awake, than in the afternoon, so plan accordingly. If you are cross-examining a child, don't ever say, "You're a liar, you're lying." All that does is upset the child, probably reduce it to tears, and perhaps prevent the child from answering any more questions at all. And of course, the jury will hate you. Far better to say something like, "Did that really happen?" Or possibly, "Did you make that up?" As you know, cross-examination does not mean examining crossly. When you cross-examine a normal adult, it is perfectly proper to use an assertion as a question, using the inflection in the voice to indicate that it is in fact a question. "You wanted Robert to go away?" This approach is wholly inappropriate for a child, who probably will not even recognise that it is a question and that an answer is expected. And children are accustomed to obeying adults in authority and may feel unable to disagree with an assertion. A jury and a judge will soon spot that a child is merely agreeing with everything a forceful adult says, and then the evidence becomes completely worthless. The question should therefore be, "Did you want Robert to go away?" Avoid the use of tags at the end of questions, such as "didn't you?" Linguistic devices of this nature can be disturbing for a child and at times confusing. So abandon questions such as, "You wanted Robert to move out of your house, didn't you?" Instead say, "Did you want Robert to move out of your house?" And always avoid double negatives, which are difficult enough for adults to follow, let alone a child. If you need time to look up something in your papers, or even time just to think about your next question, do not just ignore the child or leave the child wondering what is happening. Just say something like, "Johnny, I just need to look at something for a moment, then I shall talk to you again. I won't be long." Never ever ask a child to demonstrate a sexual act or to touch an intimate area of its own or someone else's body. Depending on the ability of the particular child, you might instead use a doll or possibly a body map. And remember always to use the child's terminology for parts of the body, however silly or childish that term might be. In England, child witnesses for the prosecution almost always give their evidence in chief by way of a pre-recorded interview with a specially trained police officer. The advocate who wishes to cross-examine must submit a list of the proposed questions in advance, either to the judge or, if an intermediary for the child has been appointed by the court, to the intermediary. The function of the judge and intermediary is solely to decide whether the form of the questions is correct, whether the language is appropriate for the particular child, whether the sequence of questions is suitable, and whether the intended length of the cross-examination is acceptable. So the judge or the intermediary may suggest the use of a different, a simpler word in a question. or recommend that a long question is broken down into 2 or maybe 3 shorter questions. The sole purpose of this collaborative approach is to aid communication between the advocate and the child witness. It is to enable the child to give its best evidence. Those proposed cross-examination questions do not go to the other party, which is usually but not always the prosecution, because in some trials a child may be a defence witness. The other side has no right to be forewarned of the questions, far less any right of veto or any role in their wording. I shall talk separately about the need for proper training or briefing of the judges so that they can perform their functions fairly and appropriately in these very difficult cases. Re-examination is rarely necessary with any witness at all. It is even less appropriate with a child witness. The only time that I might, and I emphasize might do it, is if I thought that the child did not understand a particular question in cross-examination because the language used was too advanced for the child. This should not arise because of our procedure of the judge or the intermediary looking at the questions before the trial starts, but it could still happen. Let me take an example. The child witness is 6 years old. The question in cross-examination was, "Did you despise Charlie?" There was a long pause, and then the child said yes. But as I watched the child as she gave her evidence, I was doubtful if she knew the word despise, and I wondered if she was simply agreeing with the cross-examining adult. I might, therefore, in re-examination, ask this: "Lucy, what does the word despise mean?" If, as I suspect, she cannot answer, then I would say, "That's all right, Lucy. Let me ask you a different question. Lucy, did you like Charlie, or did you not like Charlie?" If you think about it, everything that I have said is plain common sense. It is just that being an advocate, a good advocate, is extremely hard work. You have to know the law and the facts. That's difficult enough, without the added difficulty of having to adapt your advocacy for each witness. And this is why preparation is so very important. Let me turn now to witnesses who claim to be the victims of sexual offences. In the main, they are female, although everything I say applies equally to any alleged male victim. A sexual offence is a violation of a person's autonomy. It can strip a person of her dignity and self-worth. It can create a feeling of no longer having any control over her life and her body. Punch me and I will feel pain and anger. I will perhaps get bruised, but I will get over that and I will recover. But rape me and I will feel utterly crushed and destroyed, perhaps forever, even if I have suffered no physical damage. The real pain is in my mind. It is very common for a victim of a sexual offence to blame herself. I must have said or done something wrong to make him do this to me. I am worthless. And all these thoughts can have an impact on the quality of her evidence, and on her demeanour as she gives her evidence. And what happens at court? First, she has to relive the whole experience again. Then she is attacked in cross-examination and accused of lying. We have a job to perform as advocates, and that is to help the woman give the best evidence of which she is capable, and to give her the best possible opportunity of being believed. And that all starts before the trial has even begun. The process begins with the police investigation. In England, we have had to re-educate our police in how to handle allegations of sexual offences. The police are now expected to approach every complaint with an open mind, to take down full details without making sarcastic comments, without suggesting to the woman that she must have asked for it because she was wearing a very short skirt or bright red lipstick. Of course, it doesn't mean that the police should automatically believe every word that the woman says. Of course, they must probe her account and raise with her inconsistencies and discrepancies in that account. But they must do so professionally and with courtesy, and they must understand that it may well take time and even more than one interview before she feels able to provide a full and complete account. Many of the problems that we had in England arose because of a general lack of understanding about how a person may behave when a victim of a sexual offence. When people hear that a woman has been raped, they often have a mental image of a female being dragged from the street into a dark alleyway and there brutally raped on the ground by a complete stranger. They believe that she will fight her attacker and scream loudly. They believe that once the attacker has fled, that the woman will immediately complain to the first person that she comes across. They believe that there will be visible injuries on her genital area. They expect her to be angry and upset when giving evidence in court. But we advocates know that life simply is not like that. In English law, rape is the penetration of the vagina or the mouth without the consent of the woman and the defendant not reasonably believing that she consented. Consent, of course, is not the same as submission. It involves having a free choice. Some women are indeed dragged off the street and into an alleyway where they are raped by a complete stranger. But others are raped in their own homes by their husband or partner or relative or friend. Some are raped at a party, at a bar or nightclub, or on the beach by someone they know. Some victims may indeed fight back and scream loudly. Others may be utterly frozen in shock, totally unable to move or to say anything. A wife raped by her drunken husband may consciously decide not to resist physically or verbally for fear that he will turn on their children. Some victims will find the courage to complain immediately to the first person they come across. "Help me, please. I've just been raped." Others are in a state of complete and utter disbelief at what has happened, and the only way that they can deal with that trauma is to do and say nothing. They try to force it out of their minds and occupy themselves with their normal day-to-day activities. It's almost a state of denial. It may be days, weeks, months, or even years before they are mentally strong enough to speak out. And when the abuser is a member of their own family, it is even harder to speak out because of the irreparable damage it will do to the family. Often, it is only when the victim fears that the abuser is about to target sexually another member of the family that the victim feels compelled and able to say what happened to her. We all know that a late or delayed complaint is not a false or untrue complaint just because it was not made immediately. What about a lack of injuries? Any doctor will tell you that even the penetration of an erect adult male penis into the vagina of a child will not necessarily leave any visible damage to the girl's genital area. The absence of any injury does not mean that penetration did not take place. Of course, for a prosecutor, it is a bonus if in fact your victim did receive some injuries. Although, of course, the defence is then likely to be that she liked rough sex. But generally, the public assume, wrongly, that a victim of rape will have sustained injuries to her genital area, and the public are concerned if she has not. Likewise, at trial, many members of the public expect a certain demeanour from the victim when she gives evidence, and they are surprised if she comes over as flat or unemotional. They do not realise that that is simply her reaction to the trauma, her way of dealing with it. It is our task as advocates to help our witness to give her best possible evidence, and our task to explain to the jury that their preconceived expectation of how a victim would behave is in fact nothing more than a myth. There simply is no standard victim, just as there is no standard defendant. Again, I shall say more separately about training for judges on this topic. So let's consider how to handle at trial an alleged victim of a sexual offence. Your manner, your demeanour will set the tone, so it is important to get it right. It will help the victim enormously if you are calm, measured, and professional throughout. Short questions using straightforward language are again an absolute must. Take her slowly and methodically through the events. Don't jump forwards and backwards in time, which can confuse, but deal with everything in a logical fashion. Be patient and listen carefully. It is highly likely that you will need to ask follow-up questions to elicit all the information that you need. But keep in mind what I have said about the myths that may be in the thoughts of the jurors. So, for example, if the witness did not fight back or scream, gently ask her to explain why that was. But make sure that your tone is not accusatory or critical, but gentle and neutral. For example, please tell the jury why it was that you did not feel able to scream. Or what did you think would happen if you tried to resist? And don't forget to smile as you speak to her. It will encourage her, as she will see you as a friendly, supportive helper. When she struggles to speak about the worst parts of her ordeal, it can sometimes assist to say to her, "Just look at me and say it quickly, and then it will be done." If she needs a break, then of course she must have it. But don't encourage too many breaks, because that in fact can make it harder for her to return and to continue what she is clearly finding very difficult to do. Time does not permit me to say any more on the topic of questioning young or otherwise vulnerable witnesses. Suffice to say that a very high level of skill is required, but that is not beyond any of us if we simply think hard, understand the difficulty, empathise, and of course prepare thoroughly. My next talk is going to be a short talk on the prosecution of sexual cases. Sexual cases can be some of the hardest to prosecute, far harder than even a murder trial. Almost invariably, sexual offences take place in private. It is a pretty foolish defendant who commits a sexual crime in a public place, in plain sight of numerous witnesses, or immediately in front of a closed-circuit television camera. In the vast majority of cases, only two people are present, the complainant and the defendant. So how do we prosecute these cases to best effect? Obviously, the start point is the statement or interview of the complainant. How compelling is it? Are there any obvious motives for her to be lying or mistaken? For example, was she recently sacked by the defendant from her job and made her allegation of rape against him a week later? Has she recently discovered that her boyfriend was cheating on her and threatened to take revenge against him? It may be that you will want a further statement taken from her, although this must be taken carefully and not in any hostile manner. Always treat her as a genuine victim until proved otherwise. Did she complain to anyone? When? In what circumstances? And was her account to that person consistent or inconsistent with what she has told the police? If it is inconsistent, why is it inconsistent? Was she embarrassed to tell the full account to the police? Sometimes it is easier to disclose to a friend that your boyfriend or husband has hit you than to disclose that he has raped you. Or it may be easier to say he raped me, but not say that he anally raped me. The jury will need to have an explanation for any inconsistency. But if you do have good evidence of a complaint, and that complaint is consistent and compelling, you might wish to start your case with that witness in order to set the scene. With the complainant, how clear is her recollection of the incident? Had she been drinking alcohol or taking drugs? Is there evidence that she was so very drunk or drugged that she could not possibly have been capable of consenting to sexual activity? Where did the incident take place? Most women, and indeed most men, preferred to have sex in the comfort of a bedroom or on a sofa, not amongst dustbins in a smelly, dark alleyway, not in a muddy field when you've got your best clothes on. Women in particular, I would suggest, like a level of romance. So some photographs of the scene might paint an interesting picture for the jury. Medical evidence and photographs may also be available. If her arms were restrained, are there bruises or grazes where he held her? But do not be surprised if there are no injuries at all. Remember that some victims simply freeze during a traumatic episode. In those instances, consider calling as a witness a doctor who can explain to a jury that no injuries would be expected in such circumstances. In that way, the jury is not left with unanswered concerns. Forensic evidence can be very important, especially if the defendant denies that he was there. If his semen is present on vaginal swabs taken from the complainant shortly after the incident, then the defendant has got some real explaining to do. If she has said that she scratched her attacker, then there is every likelihood that a match to his DNA will be found in a swab taken from beneath her nails. There may be fibres that match her clothing on his clothing, or vice versa. All of this can help your case. Presenting technical or scientific evidence to a jury is not always easy. Some expert witnesses are brilliant at explaining their area of expertise to ordinary people. Others are brilliant at their job, but utterly hopeless at speaking about it in simple to understand language. Make sure that you understand what the evidence from the expert is before you begin to present that evidence to the jury. I often find that it is worth asking the expert to give his, and of course, obviously I include female experts in that term too, to give his conclusion first and then get him to explain how he reached that conclusion. In that way, the jury immediately grasps what the conclusion is and may not then worry too much if they did not understand all the science behind that conclusion. If your expert uses lots of technical terms, always stop him and ask him to explain that term in simple language. A good expert is perfectly happy to and perfectly capable of doing so. If it helps the expert to give his evidence by drawing a diagram or demonstrating with a prop of some sort, then do that. A visual image is not only interesting for a jury, but also more memorable for them. Cases where there has been a delay in reporting to the police present greater problems for we advocates. Forensic opportunities have been lost, but there may be other supporting material available. You may have evidence of a change in behaviour of the complainant after the alleged incident. Have friends or family notice that she is much quieter than usual, that she is prone now to unexplained unhappiness or tears, or keen to avoid being in the company of the defendant, and so on. And of course, do not forget telephone and social media evidence. How many defendants have stupidly bragged to their friends of their exploits on Facebook, or photographed themselves engaged in a sex act with a female who was clearly unconscious or otherwise incapable of consenting. And if the defendant tries to suggest that the woman clearly wanted sex because she had a short skirt on, turn it back on him. Is he really saying that a woman cannot choose exactly which men she has sex with? Does he have no respect for the right of every woman to say no? After all, even a prostitute has the right to choose her clients. Is he so arrogant, so full of himself, that he thinks that every female should want to have sex with him? A lot of defendants manage to convict themselves by their arrogant performance in the witness box. As I said at the start, it is very hard to prosecute sexual offences. Do your utmost to put forward the strongest case that your evidence properly permits, and try to dispel the erroneous myths that exist in this field about how victims of sexual offences behave. But never forget that not every complainant is truthful, and that the standard of proof required in a criminal case is, quite rightly, very high. You will succeed in some cases and you will fail in others. That is the life of an advocate. Statistics are for politicians, not for us. My last talk is on the topic of the need for judicial training. We used to be terribly arrogant in England and assumed that once a lawyer was appointed as a judge, then he or she, and from now on I shall simply say he, knew everything and no longer needed any training. We were wrong. We all have much to learn, judges included. There is now in England and Wales a judicial college, and it does a vast amount of truly valuable work. The importance of judicial independence is respected, in that it is the judges who are responsible for the education and training of judges. They may enlist the help of an advocate, or the help of a police officer or a probation officer, or an expert in one field or another for a particular topic, but they, the judges, retain responsibility for their training. One of the areas where our judges needed and undertook training was in how to deal fairly with child or otherwise vulnerable witnesses. Another was in seeking to dispel the false ideas or myths that some jurors believed about how a victim of a sexual offence would behave. Our judges are now proactive in ensuring that all vulnerable witnesses are treated with proper respect for their needs. The goal is simple: to treat them fairly and to enable them to give their best evidence. Neither of those goals in any way detracts from or diminishes the judge's obligation to treat the defendant fairly and to ensure that the defendant receives a lawful and fair trial. The judge will seek to identify at an early stage in the proceedings whether a particular witness is vulnerable. If so, he may appoint an intermediary, and he will direct that the witness gives evidence on a fixed date and at a fixed time, often the morning. He will order a pre-trial visit by the witness to the courtroom so that the witness can be made familiar with its layout, who sits where. He will decide whether we wear our robes or not. He may direct that the cross-examining advocate submits his questions in advance to the judge or intermediary. He may set a time limit on how long the witness will give evidence, how frequently the witness must be given a break, and so on. At the trial, the judge will frequently go with the advocates to speak with the vulnerable witness before the witness gives evidence, and that is to ensure that the witness knows what is going on, what is going to happen, and understands that it is perfectly all right to say, "I don't understand," or "I can't remember," or "I need a break." There is, of course, no discussion at all about the actual evidence, because naturally the defendant is not present. All that the judge is doing is trying to put the vulnerable witness at ease, while stressing the importance of just telling the truth and not making anything up. Obviously, some judges are better at speaking to vulnerable witnesses than others. Those who have young grandchildren can be particularly skilled at speaking to child witnesses, but not always. And this is where the judicial training can be especially valuable. The other area where I mentioned that judges had welcomed specific training was in the handling of trials of sexual offences. As a result, in England and Wales, judges direct juries specifically about the danger of having preconceived notions as to how a victim of a sexual offence will behave. The judges have been educated about the myths on rape that prevail amongst the general public, and they now take action to dispel them so that both complainants and defendants receive a fair trial. These are just two of the areas where our judges have trained themselves with outside assistance to be better judges. My advice to you is simple. Work with your judges for a better system of justice. Invite them to attend your lectures so that they can see the wisdom of your suggestions and adopt them themselves. They must, of course, retain their independence, but that does not mean that they cannot be encouraged and assisted in their task. Good luck.